Election law will get the lion's share of attention during the United States Supreme Court's 2022 term. Good afternoon, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbut. Yes, you heard that right. The Supreme Court agreed 2 days ago to take up an election law case out of North Carolina that promises to be a doozy. Breathless court watchers all agree on that, but they do not agree on how far any change in election law can reach. We're going to talk about the question that particular election law case raises and how the court might answer it. Before I begin, I do want to shout out to the sponsor of this channel, which is Conservative News and Views, link in the description. Be sure to check out the awesome CNAV Store. Scroll down near the bottom of that link. Lots of good merchandise there, including this t-shirt. Facts do not cease to exist because they are ignored. Yes, well, we're going to talk about one salient fact in the Constitution that the left wishes would go away. The Elections Clause in the Constitution. The Supreme Court does not have a comprehensive report of all the cases on the docket. Instead, it provides a docket search tool. I've left a link to it in the description. If you know the docket number or the name of either party to the case or any other word that might show up in the case docket report, you can find the case. Each docket result comes with a link to a one-page PDF document showing what questions the case presents. The database has every case pending or decided beginning with the 2001 term of the court. Now, Mr. Dylan Stableford at Yahoo News highlights 3 cases he, at least, will watch carefully beginning this fall. He begins with Students for Fair Admissions versus President and Fellows of Harvard College, 20-1199, and Students for Fair Admissions versus University of North Carolina et al. 21-707. Both cases aim squarely at the precedent in Grutter versus Bollinger from the 2003 term. In that case, the court held that colleges and universities could use race as a factor in admissions. That debate is decades old and goes back to Regents of the University of California versus John Paul Bakke in 1978. That case held that universities can use race as a factor, but not hold to a rigid quota of slots. The holding in that case looks suspiciously like the kind of substantive due process case that Clarence Thomas already wants to re-examine. Thomas, in fact, dissented in the Grutter case and no doubt would like to overrule it. The tension, in Grutter and Bakke both, is between Title VI of the Civil Rights Act and the perceived need to create diverse student bodies. Students for Fair Admission specifically alleges in North Carolina that the university is lowering academic standards to fill slots. Stableford then turns to 303 Creative LLC et al. Versus Aubrey Ellenis et al. That's 21-476. In this case, a website designer plans to create sites celebrating weddings and give religious messages, but the Attorney General of Colorado stands on the Colorado Anti-Discrimination Act. That act, so says the Attorney General, says that she must serve all comers and remain silent about her faith. The Supreme Court agreed to hear her petition on one question only, and I quote, whether applying a public accommodation law to compel an artist to speak or stay silent contrary to the artist's sincerely held religious beliefs violates the free speech clause of the First Amendment, unquote. The docket report lists a dizzying number of friend of the court briefs in that case. Alliance Defending Freedom will argue the matter for the petitioner before the court. And now we come to that election law case, which is drawing the most attention, and for a good reason. It immediately touches redistricting and whether state courts can interfere with legislatures in that endeavor. But it also touches the appointment of presidential electors, or at least it could. The official jaw-breaking case name is Timothy K. Moore in his official capacity as Speaker of the North Carolina House of Representatives et al. Versus Rebecca Harper et al. Everyone will likely call it by the short name Moore versus Harper, docket number 21-1271, and I've left a link in the description to the docket report. This case is on certiorari to the Supreme Court of North Carolina. The reportage in this case comes from MSN, Forbes, and Vox. This case began with the North Carolina Supreme Court rejecting a new congressional district map from the legislature. That court, finding that the maps gave the Republicans too great an advantage, substituted their own maps from their own special masters. Speaker Moore asked for an emergency stay of that substitution. The Supreme Court denied the stay, saying it came too late for midterms. But Justice Kavanaugh, though agreeing the stay application came too late, said the court should grant certiorari if the legislature asked for it. I quote from his first paragraph. I agree with Justice Alito that the underlying Elections Clause question raised in the emergency application is important, and that both sides have advanced serious arguments on the merits. The issue is almost certain to keep rising until the court definitively resolves it. Therefore, if the court receives petitions for certiorari raising the issue, I believe that the court should grant certiorari in an appropriate case, either in this case for North Carolina or in a similar case from another state. If the court does so, the court can carefully consider and decide the issue next term after full briefing and oral argument. Unquote, Justice Kavanaugh. Now, because they didn't get the stay, midterms will go on in North Carolina according to the North Carolina Supreme Court Special Masters map. But the U.S. Supreme Court might let the legislature go back to its map for the presidential election of 2024. In fact, Speaker Moore filed a question presentation going far beyond the narrow question of redrawing district maps. He wants the court to determine, and again I quote, whether a state judicial branch may nullify the regulations governing the manner of holding elections for senators and representatives prescribed by the legislature thereof, U.S. Constitution, Article 1, Section 4, Clause 1, and replace them with regulations of the state court's own devising based on vague state constitutional provisions purportedly vesting the state judiciary with power to prescribe whatever rules it deems appropriate to ensure a fair or free election. Unquote, Speaker Moore. Now, enough of the preliminary. Now I'm going to talk about what the Constitution has to say. I've left links into the description to the original Constitution and to Amendments 11 through 27, two web pages from the U.S. National Archives. Now, Article 1, Section 2, Clause 3 says that we apportion representatives among the states according to population. That clause says nothing about who draws the districts. Legislatures inferred their power to draw congressional districts from the Elections Clause. That's Article 1, Section 4, Clause 1. And I'm going to quote it entirely now. The times, place, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may at any time by law make or alter such regulations except as to the places of choosing senators. Close quote. Now that last part dates back to the old way of choosing senators by the legislatures themselves. Not even the 17th Amendment, providing for popular elections of senators, has changed that. Now, notice the qualifier in that clause about how Congress may change the legislature's regulation. It says to do so by law. Article 1, Section 7 sets the rules for how a new law comes into being. Laws come from legislatures, but go to the relevant executives for approval or disapproval, or veto. So law here means a joint undertaking by legislature and executive. Laws are subject to court review. Does the prescription by a legislature of when, where, and how to elect senators or representatives qualify as a law? Look carefully. The Constitution doesn't say that. Could it be that such prescription is the sole prerogative of the legislature and no other authority may gainsay it? Yes, I hear you already scratching your heads and asking, gain what? To gainsay someone or a group of someone's is to tell them no. Another word for that is to countermand. Now, you may or may not have heard already that someone is asking about presidential electors. Well, what about them? Well, they might not seem to be at issue in a redistricting case, but the question, as Speaker Moore worded it, would certainly apply to electors. Article 2, Section 1, Clause 2 begins like this, quote, each state shall appoint in such manner as the legislature thereof may direct a number of electors, close quote. Similarly, the 23rd Amendment says the Federal Capital District, which we call the District of Columbia, quote, shall appoint in such manner as Congress may direct a number of electors, close quote. Here again, where do the words by law appear? They do not. Everywhere else the Constitution directs or permits Congress to act, direct, or provide, except for constitutional amendments, it always says by law. For instance, Congress may, by law, provide for what happens when neither president nor vice president qualifies for office. Similarly, Congress may, by law, provide for a body other than the cabinet to decide presidential ability or fitness for office. But to direct the appointment of presidential electors from the District of Columbia? No. And for legislatures to direct or the appointment of presidential electors from their states? No. So, if not by law, how else? By joint resolution, of course. In fact, no Congress proposing constitutional amendments has ever submitted these to a president for approval or veto because, again, Article 5 provides that Congress shall propose, not by law propose, but merely propose. There is your precedent for saying that neither governor nor state judiciary shall interfere with the legislature in these matters, in redistricting or anything else. Scholars and commentators call this the independent legislature theory. Now, before I get into this any further, I want to shout out to another sponsor, BitNext. This is your replacement for Zoom, Slack, the Google G Suite, Microsoft Office 365, Dropbox, WeTransfer, and Chili Piper, among others. Unlike any of them, BitNext protects your content and conversations so well that even the administrators can't see it. So this is your channel for secure comms, conferencing, cloud storage, file sharing. Best of all, everything is back-end, so you don't even need client software. If you have a browser, you can use BitNext. Follow the link and give them a try. 28 days free of charge. You can't beat that with a stick. All right. Now, where were we? Oh, yes. Independent legislature theory. The reportage sources call it a fringe theory, but it derives from a careful reading of the Constitution as amended. If that theory is false, then no constitutional amendments have ever been valid because no one sought presidential approval. Had the Constitution said that the legislatures would, by law, prescribe times, places, and manners, courts would have a role. So would governors. This calls into question every instance in which legislatures have delegated their district drawing authority to either their respective Supreme Courts, with or without special masters to assist them, or independent redistricting commissions. The second part might still hold because in Arizona State Legislature versus Arizona Independent Redistricting Commission in 2015, the court essentially held that the legislature, having delegated authority to such a commission, couldn't undelegate it so easily. Now, is that going to hold? I'll get to that. Hold that thought. But I have to tell you, the record of such commissions is spotty anyway. Virginia amended its constitution to create such a commission, but that commission bogged down totally in partisan bickering. So the Supreme Court of Virginia appointed 2 special masters to draw districts. Again, Justice Kavanaugh signaled a willingness to grant cert. Indeed, the court did grant cert just 2 days ago, and they did it without comment. I've left a link in the description to the order list. You can read it for yourselves. In fact, it'll go directly to the page involved. Now, Justices Alito, Gorsuch, and Thomas, in addition to Kavanaugh, have shown willingness to consider the Elections Clause and what it implies. Justice Barrett has had no occasion yet to express an opinion on that matter. This case began as a redistricting case. To some extent it still is. If the Supreme Court finds for the Speaker, then the legislature's map takes effect for the election of 2024. Presumably that map would hold until the 2030 census. But given the Elections Clause, it affects all areas of election law, at least for federal elections. And because North Carolina is not an off-year state, this affects state and local elections there also. Now, hypothetically, Louisiana, Mississippi, New Jersey, and Virginia could hold state elections according to different rules from federal. Kentucky could likewise hold its governor's election by different rules. These are the off-year states, but they are not likely to go to all that trouble. Now, this case also affects the appointment of presidential electors because the Electors Clause similarly lacks a by-law phrase. Thus, legislatures could appoint presidential electors directly if they wanted to. The federal Constitution being the supreme law of the land, per Article 6, no state authority could countermand them. That thought gives the political left nightmares if the reportage, especially from Vox, is any indicator. Vox cites a precedent, Davis versus Hildebrandt, 1916, in which popular referendum could supersede the elected legislature. According to that precedent, any body, including the people voting in referendum, having any legislative power could handle these tasks. But the Davis precedent cannot hold to uphold the authority of a court to countermand a legislature. In any case, the court rejects stare decisis as an inviolable constitutional principle. We saw that last term. Now let me tell you, the left is deathly afraid of this case. Their fears go far beyond redistricting, although that in itself gives them the heebie-jeebies. They have watched Republicans gain control of more and more legislatures. This upcoming midterms could wipe the left out in all but a relative handful of states. And if this wipeout continues to the 2030 census, they might reasonably fear that they'll never control the House of Representatives again. Furthermore, we have already seen the left try to federalize election law by relying on Congress' power to by law make or alter such regulation. They did so essentially to replace in-person voting with mail-in voting everywhere. That's because everyone who cares to observe can see that mail-in ballots skew left. That according to the celebrated law firm of Dewey, Cheatham, and Howe. But seriously, I've left a link in the description to an article I wrote in which I ran a chi-square test on last year's governor's race in Virginia. I showed positively that mail-in ballots skew left. The left knows it and they're counting on it. And by the same token, the left wants to federalize the drawing of congressional districts. In Moore versus Harper, the Supreme Court could forbid the left to do either thing. The left cannot federalize the appointment of presidential electors. Article 2 has no make or alter clause within it. But the left fears the direct appointment option greatly. Otherwise, they would have laughed off the alleged email correspondence of Virginia Lamp Thomas. Yes, that one, Mrs. Justice, with Arizona legislators, urging them to appoint Arizona's Electoral College delegation directly. The Moore case could legitimize that kind of direct appointment, and that is exactly what they do not want. Before I close, I want to touch on one thing I'm sure all of you are wondering. Whiskey Tango Foxtrot is this Rebecca Harper person? Well, Rebecca Harper, the lead respondent in this case, is a member of Common Cause North Carolina. She used the North Carolina legislature. He sued them twice over congressional district maps. Common Cause versus Lewis and Harper versus Lewis. The arguments by Common Cause scarcely rate a mention. Absolutely any districting map that does not afford the Democratic Party an advantage is gerrymandered according to the left. Never once have they owned up to their own history of gerrymandering in the latter half of the 20th century. Nor do they propose any workable alternatives. Now, I have put one forward. I've left a link in the description to that. Among other things, I propose that boundaries for congressional or legislative districts never cross county or other unit lines. That kind of change would make much more sense to a voter. Nor have I seen Common Cause propose any election reform that addresses election integrity or security. A quick perusal of their website suggests that they would favor federalizing election and installing mail-in ballots issuing mail-in ballots automatically to everyone. They use the same buzz phrases like voter suppression that the left uses. And as the named plaintiff in Harper versus Lewis, Rebecca Harper becomes the chief respondent in Moore versus Harper. Now, the Supreme Court grants certiorari on a vote of 4 justices, the one time the majority does not rule. We do not know how the court voted in the Moore case because the order list doesn't tell us. The breathless left thinks they know who voted to grant cert in this case, but only by examining earlier opinions and counting how many justices voted to grant the emergency stay. But just because Justice Barrett did not join Justice Alito's dissent does not mean that she didn't feel about it the way Justice Kavanaugh does, that there just wasn't time to do it in this year. But if Speaker Moore asked for cert, they could take it up next term in a leisurely way. In any event, the court will hear argument next term. The court conferenced this case 3 times before the grant, as you can see if you read the docket report. Common Cause has already briefed the court in opposition to Speaker Moore's emergency stay application and his petition. Rebecca Harper is taking part separately and apart from Common Cause and has retained one of the left's favorite lawyers, Mark Elias of the Elias Law Group, Seattle, Washington. Respondents also include an outfit called the North Carolina League of Conservation Voters. Now, what interest would an environmental group have in an election law dispute? Ask them. But even now, they devote a significant portion of their homepage to this case and the dispute behind it. That's a lot of heavy hitters against Speaker Moore and his best friend of the court, the National Republican Redistricting Trust. This group is litigating 2 redistricting cases in North Dakota as we speak. One, Wayland versus Burgum, is already on appeal to the Supreme Court, or at least they say it is. I couldn't find that case on the docket. Be that as it may, Kavanaugh is right. The court can't wait. How will these cases play out? Stay tuned. Links in the description to the article, to the docket search tool, to to the docket report on the Moore case, to the Constitution and Amendments 11 through 27, to the order list, to my chi-square assessment of the skew of mail-in ballots, to my proposal for remodeling state legislatures and drawing congressional districts, and to conservative news and views. I have another link to the awesome online store and to BitNext, as I also mentioned. If you like what you've heard, you can like this video. On the end screen, I'm going to put in a subscribe link and also a link to yesterday's video reviewing the 2021 term of the Supreme Court. This is Terry A. Harper delivering another declaration of truth and reminding you to let the truth set you free.